Just one point. Would it inconvenience anyone, or would it be impossible for anyone, if we sat at 10 on Wednesday rather than tomorrow morning in order to make up for the fact that we're going to rise early in any event tomorrow?
My Lord, I'm sure it won't. I can ask those behind me and we can let you know before the...
I'm sorry to... Thank you very much indeed.
My Lords, could I ask you please to turn to our written case, Core Volume Part 2, page 162. Paragraph 68, where we have set out a number of principles that can be derived from the European Patent Office cases. And what I wanted to do was to just take your lordships to three of those cases, my best three, I suppose, and then return to the Court of Appeal judgment, show you how they dealt with the European Patent Office law, and then show you how we say they fell into error. So, my lords, the three cases I'd like to turn to, please. Firstly, Zachariah, which we refer to in little d. The key is providing enough information to permit the skilled person to be able to carry out the invention. And that can be found in Authorities Bundle 6 at tab 62. And it's page 3443. And it's paragraph 6.2.
Paragraph?
6.2 on page 3443. So the points I take from this is that it's a flexible test. This was a case, in fact, about a cold fusion theory. So this was perhaps in the more unbelievable field. But in the end, what is required under Article 83 is the provision of all the data which the skilled person will need to carry out the claimed invention, because they're not expected to just do it by trial and error. And of course, we say that that standard was met in this case. Then, if I could go, please, to the Ibsen case, which is at tab 68 of this bundle, and page number 3532.
Well, the case you've just given us, Zachariah, it seems to be rather, in the proposition, I take it the proposition you're relying on is the one in the sentence beginning, however, if the invention seems to offend against generally accepted laws of physics.
Yes, yes. So that wasn't say it was a cold fusion case.
Yes. Well, that's not this case, is it?
It's not. So the burden for the patentee was higher in that case because it was a more difficult.
No, but that's That's because if you have an invention which looks like nonsense and you're expected to produce, if you're going to emulate it, something which offends against the law of physics, you need to have an explanation as to how you evade generally accepted laws of physics. Isn't it addressing a rather different problem from the present one?
Well,
I mean, there's nothing. Here we've got an invention which either works or not in respect of pain.
Your proposition seems to be that it's always necessary to demonstrate in the application that the invention is feasible, whereas this proposition is if the invention is conditional on the invention offending against what one would ordinarily expect, that it's then necessary to demonstrate that it is actually feasible.
Yes, and that's the level that the EPO look at it. They only look at plausibility if there is a doubt about feasibility at all. And it's a flexible test because it depends on how believable the invention is. But in the end, the question is, can you carry out the invention at the priority date without undue burden?
The real question, surely, that we've got to face is how do you apply this to a case where the invention has already happened and the new patent is for a different use? And what effect does the rather radical change of context have on the level of disclosure required?
Yes, I think I would take issue, my lord, with your suggestion the invention has already happened. It's right that pre-Gabelin had been
identified. The product
identified.
has already been invented.
Yes.
The use has not. Now, that is a context in which one needs to look, at least arguably needs to look, at plausibility for a different purpose and in a rather different light. So I'm not sure that the role of plausibility in a case where there's going to be enormous disclosure to enable the skilled person to replicate it anyway is really much help, because here we're dealing with a case where replication is not the problem, it's explanation that's the problem, explanation of the feasibility of the suggestion that the new use will work.
But in my submission, in the end, the only question is, can you replicate it? If you have disclosed it in a sufficiently that the skilled person can work the invention at the priority date, then you have fulfilled the bargain.
But the logic of that is that you work the invention by using it. So all you need to disclose is this works if used for pain.
Yes.
And you don't need the rat experiments at all on your case, do you?
Well, you need to have some reason.
Why? Why on your
think,
case?
Because that's then you start to get into the armchair inventions where there's no basis, and the skilled person is just left. Well, I've got to do the research from scratch. I've been given a suggestion. It's no more than a suggestion, and therefore I'm not given the invention. I'm not given any reason to believe that what's said in the patent is true. And we would contrast that with a case where you have given experiments and you've shown that it really.
Yeah, but we are really, it seems to me, unless you can show us a European Patent Office case which is closer to the present, we're really inventing a new element for the reason you mentioned, namely that we don't want to encourage armchair whiz kids to use their computers to produce every conceivable answer, to patent everything under the sun.
Yes. Well, I will show the third case I'm going to show is the one we say is closest on the facts, so I'll come to that.
I mean, the problem about the submission that you're making, seems to me, is that the logic of it is that there's no requirement of plausibility at all, that you either have a plausibility as an independent requirement, or you have no requirement of plausibility at all. Both of those are logically defensible propositions. You are, for very understandable forensic reasons, trying to navigate between these two. And I think that slightly undermines the coherence of your argument.
Well, what I hoped I submitted earlier is that it's a shortcut way of trying to work out whether Article 83 has been satisfied when you've got no evidence and it's early in the life of the patent. One way of looking at whether or not it works is to say, well, is it plausible it works? And if it's not even plausible and there's no evidence, it's likely it doesn't work. And so in the end, you have to come back to Article 83. And as the European Patent Office use it, it's a shortcut, an evidential tool, and that's all that it should be.
But if it doesn't work, there's no inventiveness, isn't that right?
Absolutely.
So it's a different point then.
Well, you'd still have to adduce, the person applying to revoke the patent would still have to adduce the evidence, as they did in the generics and Yada case, to show that it doesn't work, even if on its face it looks plausible. So it will get revoked at a later date, based on the fact it wasn't workable at the date of the invention.
So plausibility is not a test of whether it's inventive or not. It may look implausible and therefore encourage you to take a point on lack of inventiveness. It doesn't work, but it's different. Seems to me a different area for the moment.
Well, it is. It can be. It is used in the European Patent Office in relation to inventive step as well as sufficiency. But in these cases where the claim involves a technical effect, that is to say, curing someone's pain, then the European Patent Office have said you must therefore, for it to be sufficient, it has to actually be able to do that. And therefore it's a question of sufficiency rather than a question of inventive step. If the claim only doesn't involve a functional technical feature, it said its plausibility is only relevant to inventive step. And the next case I was going to show you is an inventive step type case. So that's at tab 68. And it's Ipsen. This is a pharmacology case. So this is a use of a somatostatin agonist in a pharmaceutical formulation. And on page 3532...
This isn't a second use case, I don't.
This...
Tell me if it is.
Someone will tell me if it is. I think it probably is because... Oh. Yes, it is. So paragraph 13 it is a statement of principle about experimental proof.
Yes.
And then paragraph 15, they set out their evidential hurdle, and they explain that you only need to look at plausibility if there is substantiation of doubts, and it's thus far from straightforward that the claimed invention solves the formulated problem.
Where do we find the statement that one only needs to look at it to dispel doubts?
This is paragraph 15, my lord, on page 3533.
15.2, is it?
15, at the top of the page 3533, the first 15.
Oh, I see. Sorry, I'm looking at the wrong paragraph.
So how would you apply that in the present case? Have the courts below applied that approach? Have they looked at this patent and said, well, nobody's ever come up with a single medicine that covers all types of pain before, and therefore it requires some substantiation that it does?
Well, in this case, we would say that there was no substantiation of doubts at all. No one said, even Dr. Scadding, when he gave his evidence in his second, he didn't say, I don't think it will work. He just says, well, I don't think that central sensitization is necessarily relevant to central pain. And when he was asked, do you think it's plausible? Do you think it will work? He said, yes. So we would submit that if this EPO approach is applied, the courts below shouldn't have bothered looking at plausibility at all, because the standard was their substantiation of doubts about suitability. And was it far from straightforward? That never arose at all, because it was perfectly straightforward to carry out the tests, the Bennett test.
Is it possible to say that it's expressing a general provision right across the relevant field without looking quite carefully at the factual matrix which the EPA was addressing in this case?
Well, certainly, of course, each case...
I realise that may take more time,
yes.
But at the moment, I feel great caution in assuming that they're laying down some generally applicable principle here.
Well, of course, each case turns on its facts, but this wording, the substantiation of doubts, appears in case after case, and perhaps I can show you Mr. Copeland
Is
will
it
find
clear
the
that this is
reference
a
in the case
second
law.
medical
Sorry.
use case?
Sorry, my lord.
Is it clear that this is a second medical use patent?
It's certainly a medical use patent.
Yes,
I'll-
that
I'll
I can
again
see.
Make sure I can.
But I'm looking for any indication that it is a patent for an existing invention in a new use.
Yes, I mean certainly somatostatin is a known biological product. That's the use of somatostatin or an agonist.
Well, claim 1, the use of somatostatin for the treatment of.
Yes.
Yes.
But what we don't know, at least I haven't found yet, is whether it had previously been patented for some different use.
I will get Mr. Copeland will find that, and I'll come back and make that point good when we've done that. So, if I could take you to the closest case on the facts, having with the proviso, of course, that each case has to be understood on its facts. That is at Authorities tabs bundle 7, tab 77.
Page?
Sorry, page starts at 3822.
Thank you.
And this is a case about dasatinib, another pharmaceutical case. And again, I will make sure I give you the reference to show it's a second medical use as we go through. So if I can pick it up, please, on page 3826 of the judgment. This is a recent decision of February of last year. And the claim you can see on the bottom of page 3826, it was the use of a compound of Formula 4, or salt thereof, for the manufacture of a medicament for the oral treatment of cancer, wherein the cancer is chronic myelogenous leukemia, CML. And you can see what happened in the opposition division, and the case on appeal is summarised further up the page, 5 lines down. The board summarises the decision. They say the decision considered that in the absence of any experimental evidence of inhibitory activity of the BRCA-ABL protein tyrosine kinase, PTK, and the lack of a coherent theory which could explain such an effect, substantial doubts existed as to whether the compound dasatinib was suitable for the claimed treatment of chronic of CML. And so that was the issue: was this compound suitable for the treatment?
Sorry, I didn't get that page again.
It's page 3826.
Sorry.
Just pausing there, it suggests that substantial doubt doesn't to be established by some fresh evidence advanced by the opponent, but substantial doubt is assumed to exist where there is neither a coherent theory nor any experimental evidence.
Yeah. Yes, that seems to be the position on the facts of that case.
Well, yes, but the previous case, I think you were seeking to extract some principle in the previous case that it's up to the opponent to show substantial doubt, and then plausibility creeps onto the stage on the other side of the picture.
Yes.
Whereas this rather suggests that you're into a plausibility regime if you've neither got experimental evidence nor a coherent theory.
Yes, if reading the patent, the skilled person would have doubts, then you're entitled to look at it.
I also noticed that the previous case was actually a case about Article 56,
Yes.
which is establishing, which I don't think we even have, but which is apparently to do with establishing an inventive state.
Yes, that's the plausibility concept is used both to ascertain whether there is an invention there at all,
Yeah.
for the purposes of Article 56 and comparing the claimed invention with the prior art, and also under Article 83. So same plausibility language is used for both, and the same guess. That sort of wording is used for both, and I accept that, my lord.
Well, there was no issue under Article 83 in the previous case. It was the only objection arose under Article 56.
56, yes, but the same plausibility test is applied in both cases. So we're on page 3826, which is sets out claim 1. And then if we turn over to page 3827, if I could just pick up just about 2/3 of the way down the page, they set out an auxiliary request 3A, and they say this differs from the main request in that it contains only 2 claims, and that the cancer has been restricted to CML resistant to STI 571. And you'll see the relevance of that in a moment, because so there were 2 claims in issue here. Firstly, treatment of CML, and then secondly, treatment of CML resistant to STI 571, which was an earlier drug used to treat it. And if we go on, please, to the reasons, which start on page 3834. And if I could ask your lordships to read all of paragraph 3, 3.1 and 3.2, please. So, again, it's expressed under Article 83. Article 83 is complied with if the contents of the application as file or common general knowledge enable the skilled person to prepare the claim compound and the claim treatment can be achieved in a reliable and reproducible manner. And that's either obtained from the application itself or from the prior art or the common general knowledge. And overall, it has to be plausible. And then at 3.3, they explain the problem here. The application is filed irrespective of a broader general disclosure in the description, so it was a broad application with a number of different treatments in it, is directed to the use of generically defined compounds in the treatment of specific types of cancer, including CML. And then on the following page, 3836, just 2/3 of the way down, just above paragraph 3.5, they explain that CML is equivalent to the teaching that dasatinib inhibits BRC-ABL kinase, and that's important to understand the technical disclosure they come on to discuss. So then if we could please turn to paragraph 3.6 on page 3837. The board explained that there is no experimental evidence for dasatinib's BRC-ABL kinase inhibitory activity. But they go on to say, however, the disclosure of experimental results in the application is not always required to establish sufficiency, in particular if the application discloses a plausible technical concept and there are no substantiated doubts that the claimed concept can be put into practice. And you'll see this language being repeated case after case. And then they go on to say, in view of the considerations in points 3.4 and 3.5 above, and the analogy that is drawn to imatinib on page 46, line 30 to page 47, line 3 of the application, the board is satisfied that the application discloses at least a plausible technical concept, namely that dasatinib, based on its functional equivalence to imatinib, is suitable for the treatment of CML. There are no reasons apparent to the board as to why a skilled person would not a priori regard this teaching as incredible or implausible. As a consequence, the post-published evidence is admissible. Now, what we should have done is include in the bundles this reference on that they go back to in the application as files, and I'm going to hand that up if I may, just to show your lordships the sort of level of evidence that the EPO accepts in these sorts of cases. Thank you. Another 2, yes, I'll get this later.
Thank you.
And so, well, just so you can see the passage there, it's a 235-page document, the application, so I've only given you the relevant passage. So it's, if you turn over the front page, this is the application for the patent as filed, and then the passage they refer to is on page 46, line 30. It's the very last two words on the page, over to 47, line 3. So all that was said in this application was that the compounds of the present invention are also useful in the treatment of cancers that are sensitive to and resistant to chemotherapeutic agents that target BRCA, such as, for example, Gleevec.
So where is the cross-reference to this in the...
So it's on page 3837, in the middle of the page, they say, in view of the considerations of points 3.4 and 3.5 above, and the analogy that's drawn into it, imatinib. So Gleevec is the same as imatinib.
Yeah,
so that's
right.
So all that's said in the application is, well, it's got the same, it's useful for treatment in cancers that are sensitive to Gleevec, and that was held to be good enough. And the board said, well, there are no reasons to doubt that. So we're going to take into account post-published evidence, and they refer to that at the top of page 3838. And then they summarise in paragraph 3.7 the findings of the opposition division, and they say the opposition division held that the biochemical properties of dasatinib could not be extrapolated from the application, and the skilled person would be surprised by the application. And then in 3.8 they say the board does not agree. And if your lordships would just read that passage on the bottom of page 14, please.
And what is the opposition division?
The opposition division, that's once you get your patent, if someone wants to oppose it, they file an opposition, and that's heard by the opposition division, which is made up of an examiner and a legally qualified member and another member of the opposition division, and then that decision can be appealed to the boards of appeal, who again comprise a legally qualified member and two technically qualified members, who now sit in a separate place in Munich to hear these appeals.
Where should we stop reading?
Yes, I think just to the bottom of page 14 is fine. So in that case, there were some tests described, but they weren't the right tests. They were tests for a different type of kinase. However, it was said, well, there were some other tests known in the art which you could use for this particular kinase, and that was part of the common general knowledge, so you could carry those tests out. So this is, in effect, one step removed from the position we have in the case before you, where the tests were in fact referred to in the patent's specification. They weren't even referred to in the specification in this case. Then if we turn on to page 15, the first full paragraph, just the first 7 lines of that, they say that the board cannot follow the division's conclusion that there are a priori serious doubts as to its potential suitability to inhibit BRCA-ABL kinase as taught in the application. And they say it's apparently not uncommon for a protein kinase inhibitor to inhibit more than one protein tyrosine kinase. So again, a parallel is being drawn with the fact it can affect other kinases. Then they also, at the bottom of page 15, the last full paragraph, perhaps you should just read that paragraph, starting, the board also does not agree.
Just that paragraph.
Yes, so my lords, this is a passage which we cite in response to my learned friend's appeal. This is a passage showing that the Board of Appeal in the EPO do not equate plausibility with non-obviousness. The standards are different, and so to the extent it's suggested they should be the same, that's not the law in the EPO. What the board then go on to do is to look in more detail at the 2 familiar cases cited by every opponent to a patent in these sorts of cases, Salk and Johns Hopkins. They describe the Salk case in paragraph 3.9.1 on page 16, and they point out that the facts are very different in that case that case, the claims covered limitless and untried downstream developments, and the patent amounted to no more than an invitation to set up further research programs for which no guidance was forthcoming. That's why that was held implausible. Then they refer to the Johns Hopkins case at 3.9.2. And again, they emphasise there was no evidence in that case. That's why that was rejected. And they contrast those two cases with the case before them at the top of page 18, where they explain, having reviewed the evidence, accordingly, no further research programme was necessary in order to carry out the invention. That's in the case before them, and that's why they said it wasn't insufficient. Then at 3.10.3, they discuss in vitro assays and whether or not those can be sufficient, and they explain at the bottom of page 18, 3842 of the electronic bundle, that in vitro tests are not absolute proof, but that doesn't matter. Absolute proof is not required, turning over to page 19, and again gives you an indication of the standard which they're looking to meet. And finally, on the plausibility point, perhaps your Lordships just read paragraph 3.10.4.
This case seems to be about a situation where the common general knowledge would have been enough to show the skilled person that there was a reasonable chance that this invention would succeed. So nothing more needed to be disclosed because it was within the ordinary category of cases where prior art or common general knowledge demonstrates plausibility without the need of further disclosure in the patent.
Yes, and in particular, the common general knowledge was the tests that weren't referred to specifically in the specification, but which could be carried out and which demonstrate that it worked. And of course, we say our case is better on the facts than this because we do actually refer to the test in the patent, and so you don't even need to go to the common general knowledge. But we emphasise what they return to at the end of paragraph 3.10.4 is the question, was the invention reproducible without undue burden at the relevant filing date of the application? Answer, yes, on the facts they found. And we say that in the end is the only test that's relevant to be asked. And of course, on our facts, we say it's also satisfied. Now, the final point from this case is to show you how they treated claim 2, which was the more limited claim, the claim to CML resistant to STI 571, which I showed you back on page 3. It was in that form. It was a different request, but it's the same claim that they were coming on to discuss. So they discussed that starting at paragraph 3.13. And so having concluded that the claim to CML was plausible, they say in 3.13, this conclusion, however, does not apply to the subject matter of claim 2 of the main request, which is directed to the use of dasatinib for the manufacture of a medicament for oral treatment of CML, which is resistant to STI 571. And perhaps your Lordships would just read paragraph 3.13.1. And so the important point I would seek to draw from this case is this. Here was a narrower second claim, a claim which fell entirely within the scope of the first claim. It was not CML, but CML resistant to STI 571. And the board determined that that wasn't plausible for the reasons they give. There was no evidence that it would treat that particular cohort of patients. Yet they still allowed the broader, more general claim because they held that the general claim was plausible at the level at which it was expressed. And so, my lords, we say that this shows that the EPO will not start to salami slice up the claims, as the courts did below, unless there are narrower claims expressed in narrower terms that they are asked to look at. But where there is a cohort of patients for claim 2 here, that which might not be plausible, fine, they'll cross out that claim, but they won't cross out the more general claim, which they have held is plausible at the more general level. And so, my lords, we say this shows that the courts, in this case, before you, were wrong to start to look at these cohorts of patients within the claim to neuropathic pain. The EPO wouldn't have done that. They would have said, well, I see a claim to neuropathic pain, it's plausible. If we'd had a later claim, maybe they would have asked themselves different questions, narrower, as they did in this case. But that doesn't mean that the general claim should be revoked, and the EPO would look at it at the general level and decide whether or not it's plausible at that level and not go behind the words of the claim. So when we say this supports us on the general approach to plausibility, it also supports us on the reasoning of the courts below to divide up the claim into parts which are not expressed and revoke it on that basis. And we say both of those approaches were wrong. So, I'm sorry I've taken a bit of time over that case, but we say it does show the approach of the European Patent Office, and on facts which were more difficult than ours, the claim to CML was upheld, and we submit that shows that the hurdle was placed too high by the courts below in the present case. And your lordships will also note, if you go back to the extract I handed up, if you just read the last paragraph on page 46, you'll see this was effectively a patent for a lot of different conditions, and that wasn't a point that the EPO found hindered them in finding that claim was plausible. Again, showing that further difference on the facts, that this was a more difficult case, yet the claims were still held to be plausible. So, my lords, those are the cases I want to look at in detail. If I could now turn to the Court of Appeal's approach to the European Patent Office case law, which we can take much faster, I hope, and we pick it up, please, at paragraph 28 of the Court of Appeal judgment at core page 553. And the first thing that Lord Justice Floyd did was refer to Regeneron. And the reason, so let me preface this, the reason I can take this quickly is we don't say there's anything wrong in the law that the Court of Appeal set out. We just say that they could have added the further cases and principles we set out in paragraph 68 of our case. And when it came to applying this law, they didn't apply the right standard. So I can take it relatively quickly because...
I'm sorry, could you just repeat the page?
Yes,
now?
I'm sorry, it's page 553.
Thank you.
So they start off with Regeneron, which is at the Court of Appeal, and cite the passages from Lord Justice Kitchen at 100 and 101. And the only point to note on this is if you look at the passage in Regeneron before this, Lord Justice Kitchen also cites Lord Hoffman in Biogen, where he points out that you don't need to have a unifying characteristic to make a claim plausible if each of the elements are individually justifiable. That's also right, that's also fine. So this is only limited to claims where the patentee is seeking to rely on a single unifying characteristic to justify the claim. Then we go on to a discussion of the Salk case, paragraphs 31 to 35. And the important points here are just to point out the difference on the facts of the Salk case. And your lordships, if your lordships would just refresh your memory of paragraph 31, you can see the difficulties that the patentee faced in that case. So in particular, there were multiple factors which needed to be satisfied in the claim. The hormone had to fail to promote transcriptional activation of one group of receptor genes, also be suitable for the preparation of a pharmaceutical for the treatment of AP1 stimulated tumour formulation. And you had to do this, the argument was you could find this out by testing which of those a hormone to satisfy both of those characteristics. Yet there was no evidence at all in the specification to help you one way or the other identify the hormone or carry out the tests. And the Court of Appeal referred to the findings of the board in this respect in paragraph 33. And so what I'd emphasise from that is a simple verbal statement that compound X may be used to treat disease Y is not enough. There has to be some information in the form of, for example, and they go on to give the example in that case. And then they say at the end of the passage quoted from the board, once this evidence is available from the patent application, then post-publish so-called expert evidence may be taken into account. So it just has to be some information, and the strictures that my learned friend suggests can be taken from Salk as to the precise type of information we say is not supported by this case or any other. The Court of Appeal went on to discuss in paragraph 34 whether in vitro tests are good enough, because the patentee in Salk had said, well, in vitro tests aren't predictive necessarily of in vivo efficacy. And they said, well, as long as they provide some basis, that's good enough. The cause-effect relationship is thus made plausible. And then the end of the quote in paragraph 34, for how incomplete the data might be, they nonetheless go one step further towards disclosing the invention without leaving an undue burden to the reader. So again, they're coming back to this idea of undue burden and Article 83 being satisfied if there is no undue burden. And then, if your lordships would just read paragraph 35 and see how stark the facts were in the Salk case, which led to the patent being rejected there. So in the Salk case, there wasn't a shred of evidence that switching off the activation wouldn't affect metabolism, which in a way which wouldn't make it unsuitable as a medicine. There was also no evidence that you get relief. And they said, effectively, the subject matter of Claim 6 is limitless and untried downstream developments, and it amounts to no more than an invitation to set up further research programs. It's the very antithesis of an enabling disclosure, and you can see why the patent was refused under Article 83 in that case. And then they go on to say in paragraph 36, as for the post-published material, the board considered that it indicated that it took a few years of research work, possibly involving an inventive step, and therefore undue burden to put the claimed subject matter into practice. So this shows, in my respectful submission, that the standard being applied by the European Patent Office is a long, long way away from the standard met by the patent in this case. It has to be that is unworkable, that doesn't satisfy Article 83, which can't be put into effect, where there's not a shred of evidence and years of research work required, for it to be refused. Contrast that with the facts of this case. Then, my Lord, the Court of Appeal go on to deal with Johns Hopkins. I'll take that much more quickly. Again, there were considerable difficulties on the face of the patent as to whether or not the GDF9 molecule identified was a member of the superfamily. And in fact, there was contradictory evidence in the patent itself. And the board, in that case, said, as quoted in paragraph 38 of the Court of Appeal, line 3, the said post-published documents were indeed the first disclosure going beyond speculation. In other words, the patent in that case was mere speculation, and that's why it was refused. But they then went on to say at the end of the passage, cited in paragraph 38, that you can use supplementary post-published evidence where, as long as it's not the sole basis to establish that the application solves indeed the problem it purports to solve. And of course, we would say in this case, the post-published material that it's effective to treat central pain is by no means the sole basis to establish plausibility, because there's the evidence in the patent itself that we've already referred to that was accepted by the judge. And that's why we say the post-published evidence is admissible in this case. So, my Lords, we have no problem with the summary set out by Lord Justice Floyd in paragraph 39. We say that's correct, if maybe not complete, because of the other cases that we've referred to. And we also accept the summary in paragraph 40, and indeed we rely on the summary in paragraph 40 as meeting the points put forward by my learned friend in his respondent's notice. Or his cross-appeal on the respondent's notice. SULC is no more than an example of ways in which specification may give adequate data as not to be read as prescriptive. Finally, there's the Human Genome Sciences case summarised in paragraphs 41 onwards, and if your lordships perhaps would just read the quote from that case, Lord Newberger at para 107, and this is where we see set out the various ways the test is applied in the EPO, the educated guess, undue burden, etc. And if you wish to read that, I'll make a couple of submissions, if I may, on that. And so the points to take from that, it's of course right that that case was about Article 57, which is industrial applicability, and not Article 83. But Lord Justice Floyd explained in paragraph 42 why the two are so similar. And the reason they're similar is because the EPO used this word plausible to describe the test under Article 57, just as they use it to describe under Article 83. The common principle behind these two objections is the requirement to place the invention or its industrial application in the hands of the skill reader without undue burden. Again, going back to the wording of Article 83 and the case law which follows from it. We see that in paragraph 42. The second point to make on this is the educated guess wording is in little paragraph 8, and that comes from the zymogenetics case, which is at tab 66 of the authorities. I'm afraid I don't think I've got time to go to it now. But we can follow through these, through these references if needs be, to see where the individual phrases come from. In that case, HGS, this court overturned the Court of Appeal and said that it had applied too exacting a standard, and we see that summarised in paragraph 43. And so finally, my lords, we get to the summary Lord Justice Ford applied or reached in paragraph 46. And perhaps your Lordships would just remind yourselves of look at paragraphs 46 and 47, and then I've got a couple of observations to make on that. Our position is that Lord Justice Floyd was right in his summary in paragraph 46, but then didn't go on to apply it. And in particular, we rely on his observations that this plausibility test is not designed to prohibit patents for good faith predictions, which have some, albeit manifestly incomplete, basis. He further went on to say a patent which accurately predicts that an invention will work is, however, not likely to be revoked on the ground that the prediction was based on the slimmest of evidence. And finally, he says, the same is true, not be speculative, where the data in the specification is such that the reader is encouraged to try the invention. Well, that's precisely what the evidence was in this case. And so having made these correct summaries of the law in paragraph 46, we submit that the court did fail to apply it when it came on to the facts, and that's to which I will now turn. Paragraph 47, of course, is a point we use to meet my learned friend's cross-appeal, and we say Lord Justice Floyd was correct to reach the conclusions he did in that paragraph. So, my lords, if we now turn to apply these principles to the findings in this case, to identify the errors of the Court of Appeal, please can I pick it up at paragraph 118 on page 572, which is where the Court seeks to apply this threshold to the facts of the present case. And we'll say...
sorry, which MS number?
Sorry, page 572, bundle, in 4, volume 3. So the three errors that we submit the Court of Appeal fell into as follows. The first one is that the court failed to analyse the claim at the right level. It should not have divided the claim up into peripheral and central neuropathic pain when there was no basis in the specification for doing so. And this was the sort of meticulous verbal analysis which the courts have long since deprecated. Now, this issue was raised and dealt with by the court in paragraph 121, on page 574, and the court dealt with it in just 2 sentences in the middle of 121. It said, the skilled person would know from the common general knowledge definition of neuropathic pain that it divided naturally into these 2 parts, so to divide the claim is therefore neither unrealistic nor unfair. And we submit that that misses the point with respect, because the argument is not that the skilled person would not know that neuropathic pain could be divided up into central and peripheral components, but instead the point that the court didn't alight on is that when the claim is expressed in general terms, the question that the skilled person should ask him or herself is whether the claim in those general terms is plausible. And as we've seen from the Dasatinib case, when the claim is expressed in general terms, even if there is a subset of patients who would not be treated, who fall entirely within the general claim can be valid, even if the narrower claim is held to be invalid, because at a general level, it is plausible that patients with neuropathic pain will be treated. And it's only if you started to divide up the claim in a way that the patent doesn't, that you start to introduce these further problems, and we say that's not the way in which the skilled person would address this patent, and it's not the way in which the EPO addressed these sorts of patents, as it didn't in the dasatinib case we've looked at. So it was plausible on the findings of the judge that pregabalin would treat neuropathic pain. That should be enough. This is not an entirely speculative patent, as FPA point out in their intervention. The term neuropathic pain was clearly meant to be an umbrella term as used in the patent and should be assessed at this general level. And as we shall see when we look at the construction point, and we've already referred to, there is no reference to any of the exclusively central pain conditions in the patent. Even if it was right to analyse the claim at this deeper level, the fact is that it is plausible for all but a minority of conditions, and there were other reasons to think it might work for central pain, the effect on allodynia and hyperalgesia, the fact it's described as an anti-hyperalgesic, whilst although not a unifying principle on the findings of the court below, was at least enough to allow the skilled reader to make an educated guess. And for those reasons we say, even on the construction that the court reached below, this claim was plausible across its scope. Indeed, Dr. Scadding explained that a drug which treated hyperalgesia in one condition might very well work in another, even if there was an incomplete understanding of the underlying cause. And so we say that the test set out by the European Patent Office and referred to by Lord Justice Floyd is plainly met in this case. And indeed, we can illustrate it by reference to Claim 4. If you'll remember, Claim 4 in this case was to cancer pain, and it wasn't in dispute on the facts that the majority of cancer pain was nociceptive pain, and there was no dispute that the examples in the patent were valid and supported nociceptive pain. And indeed, Dr. Scadding's evidence, which is in the bundles at page 1027, is that most cancer pain was not neuropathic. So we would say such a claim was clearly highly plausible, encompassing as it did on the whole nociceptive pain. Yet, because of the way that the judge analysed these claims, because he held that cancer pain could include some neuropathic pain, and moreover that within this there might be some central neuropathic pain for the rare types of cancer that occur within the CNS, the whole claim was thrown out, and he declared that Claim 4 to cancer pain was invalid as a whole. And we suggest the notional observer would think that something very strange was going on, presented with those facts, and that this illustrates that the wrong approach in law has been adopted to start to salami slice these claims down to the levels which the courts below reached. So, my Lord, that's the first error. The second error that the Court of Appeal we submit made is that even if it's allowable to analyse the claim at a level beyond which it is written, i.e. to start to divide it up into central and peripheral neuropathic pain, because it is plausible for the majority of neuropathic pain conditions, it is legitimate to use the post-published evidence to verify this, as the Board of Appeal did in the dasatinib case that we looked at. And this, of course, is consistent with the EPO approach generally, because analysis of the post-published evidence demonstrates that pregabalin does work for central neuropathic pain because it's been approved for that use. Now, the Court of Appeal dealt with this in paragraph 122, and they referred to the Johns Hopkins case, and they accept that it's legitimate to use post-published evidence where there is some basis for plausibility. And we say, in answer, there is clearly some basis in this case for the claim to be plausible because it was expressed in general terms, and there was no dispute on the findings of the judge that the claim is plausible, at least for peripheral neuropathic pain. And therefore that gives reason for the court to be able to look to see if the gap can be plugged and whether there is any later evidence to support the central neuropathic pain aspect which the court found was covered by this claim. Of course, had the claim not been effective to treat some significant types of neuropathic pain, that evidence would have been adduced by the respondents on the basis we looked at earlier in the generics and Yada case and relied on by the courts below to revoke the claim. So we ask, why can't the equivalent evidence be utilised to justify what is plausible in the way in which it is described in the claim? It would be unfair not to rely on this evidence, and we submit this is precisely the sort of case where post-published evidence should be permitted to be allowed because there is sufficient basis in the speculation as a whole for the class of pain as a whole, and therefore this post-published evidence should be possible. The Court of Appeal said in paragraph 122 that it wasn't taken to any cases where post-published evidence was used to make good a prediction where there was no basis in the claim. Now, we don't have any problem with that. That's not our case. It is clear that the European Patent Office won't allow post-published evidence where there is no basis. But because of the way in which the European Patent Office approaches these sorts of claims, and as we've seen in the dasatinib case, if the claim is expressed in general terms, it is dealt with in general terms, then having seen a claim to neuropathic pain here, which is partly plausible on the findings of the judge, the court ought to have allowed the evidence to show that it's fully plausible across the scope, even if that was post-published, just as it did for dasatinib in the Bristol-Myers dasatinib case we looked at. And we point out that the respondents, although the Court of Appeal said they hadn't been shown any cases going the other way, the respondents haven't managed to find a single case anywhere in the EPO or elsewhere in Europe which supports the approach of the courts below, in this case, where a claim expressed in general terms and is plausible for the majority of the conditions covered, either should be sliced up into subcategories which are not mentioned, or where later acquired evidence is not permissible to be adduced to meet the absence of evidence in the patent. Finally, my lords, the third error, we submit that the Court of Appeal failed to stand back and apply the correct statutory test, and that is under Article 83, as the respondents now correctly accept that plausibility has to be dealt. So what the courts below should have been asking themselves is whether the skilled person at the priority date was put into the position by the patent to work the invention across the scope of the claims as they've been construed. The answer is undoubtedly yes on the evidence before the courts. There was no dispute between the experts on this. You'll recall there were two types of expert in the case. There was a clinical expert and a neuroscientist from each side. And as I referred to earlier, the judge had held that the neuroscientist would be the leading expert for the purposes of sufficiency, no doubt because of the animal models in the patent. Nevertheless, the only evidence adduced on plausibility to support the respondent's case came from the clinical expert, Dr. Scadding. And we saw his evidence quoted in the Court of Appeal judgment a little earlier. So now I asked him about plausibility in his cross-examination, and the Court of Appeal has referred to that evidence in paragraph 109. But there has been some editing of the evidence he gave in that passage. And if I may, I'll show you the transcript itself so that your lordships have the full extract before you. This is in the appendix, part 2, at page NS 1272, if I may. And the passage which the Court of Appeal referred to begins on page 572 of the transcript at line 6. And if your lordships would just scan through 572, 573 and 574, please. So the points in this passage which I rely on particularly is the answer at 573, lines 6 to 10, where the doctor explained what he thought was missing is demonstration that these drugs are effective or not effective in an established model of neuropathic pain. So he doesn't distinguish there between central and peripheral neuropathic pain. And then, following the discussion on the rest of 573 and 574, he accepts at lines 20 to 22 that the claims are supported by the data in the patent. Yes. That's where the Court of Appeal stopped. But if your Lordships would just read on over to 575, line 20. We say that the Court of Appeal should have relied on this evidence, that the Bennett test was disclosed, the skilled person would be interested in seeing it applied, and if they had applied it, they would see that pregabalin was effective to treat neuropathic pain. Yes, and that was a routine test which could be done based on the specification of the patent. So in that light, the invention was clearly put in the hands of the skilled person at the priority date. Now, Lord Justice Floyd assessed this evidence, and he dealt with it in paragraph 127, and he said he dismissed it because he said that Dr. Scadding was only thinking about peripheral neuropathic pain in this passage. Now, we'll come back to that in a moment on construction, but it does seem very unfair to reject this evidence on plausibility because of the narrow construction, but also to reject the narrow construction, which he also did. We say that's inconsistent. It should either be one thing or the other. Moreover, it completely ignores the respondent's own case that allodynia and hyperalgesia were common features of central pain, and that treating hyperalgesia with a drug that worked in one condition might very well work in another. So there was no reason for him to distinguish central and neuropathic pain when he was talking about the tests, or for his reasoning to be any different. It also ignores the evidence from the other expert for the respondents, the neuroscientist Professor Wood, who the judge said would be the leading expert on sufficiency. As I've explained, nowhere in his 5 reports did Professor Wood suggest that the claims might not be plausible across their scope because of the central pain component. He didn't separate central pain and peripheral neuropathic pain at all in his written evidence. And if I can show you briefly his evidence on workability, which if the courts had had in mind when applying the correct test, they should have placed weight on.
Just before you leave the transcript,
Yes.
Is it relevant to the point you just made about paragraph 127 of the Court of Appeal that in the transcript we have references both before and after those passages which you were relying on to central sensitization?
Yes, central sensitization is the aspect of the rat formalin test,
Yes.
which on the evidence was held to be known to play a part in neuropathic pain, and therefore that's why the rat formalin test was held by the judge to justify the claims to neuropathic pain, because it had a central sensitization component,
Yes.
and people knew that central sensitization was an aspect of neuropathic pain.
But but what I was asking was, is that an indication that actually, contrary to what the Court of Appeal thought, Dr. Scadding may have been thinking or must have been thinking about all types of neuropathic pain when he said he would have been interested in following up the
Yes,
patent?
I'm not sure that on its own is indicative because the
Central sensitization isn't a necessary component of central neuropathic pain, but it is a gateway of peripheral neuropathic pain.
Yes, nobody knew whether central sensitization played a role in central pain. It was so just because it has the word central, I'm afraid it's not as straightforward as that.
One goes back to those graphs
Yes.
or pictures you showed us, which shows
Yes,
it comes
and
in.
there was no known mechanism for central neuropathic
Right,
pain.
no,
That's why people, but we do distinguish the lack of understanding, the absence of evidence. That doesn't mean that there was evidence it wouldn't work. And of course, that's the standard which the EPO would apply and which we say wasn't met in this case. So I was going to show you briefly Professor Wood's evidence. If we go to Appendix Part 2, page 1065, and if you would look at paragraphs 122 and 124 of Professor Wood's first expert report, please.
One, two, two, and 124.
124, yes.
Yeah.
So he refers to neuropathic pain, the Bennett test being a model for neuropathic pain in 124 without distinguishing what sort of pain, neuropathic pain he was talking about. And then if we go on to paragraph 142 on page 1072, bundle. So in this passage, his evidence was because the tests hadn't been carried out, then you wouldn't know whether it was effective for neuropathic pain. But he doesn't, again, distinguish between central and peripheral. And the upshot of this is, if the Bennett test was carried out, his evidence was that it would render the claims plausible. And we go on to see, it's accepted at this stage, the difference between central and peripheral neuropathic pain as a point in the case hadn't been conceived of. But if we go on to his evidence on page 1182, in the case, this is his reply report after the point had been conceived of, paragraph 50.
This is his third report.
This is his third report.
I'm so sorry, what page was this?
1182.
Thank you.
What, 1182?
1182.
You're
Yeah.
moving from the first to the third report, yeah.
Yeah.
So the point to be made here is, even though the difference between central and peripheral neuropathic pain was alive by now, he was still making no distinction between it. And he said that the CCI and Kim models, that's the Bennett and Kim models, were both widely accepted to be useful standard animal models for neuropathic pain. And then I asked him about this in his evidence. And if we turn on, please, to page 1267, and read from the bottom of page 263 of the transcript, I'm afraid all the way to the end of
I
269.
think I must have got a wrong page number. What are you on?
Sorry, 1267.
Thank you.
All the way through to where?
From all the way from the bottom of page 263 in the mini transcript, all the way to the end of page 269, if you would.
Yes.
So, my lords, we obviously rely particularly on the passage on 264, line 9. It's a credible suggestion and one you would actually carry out the experiments to find out if it was true or not. And then on page 267, where he explained he'd be definitely motivated to look at it, and he would carry out the tests. It would have no difficulty in doing them, and once you'd done them, you would know it was effective to treat neuropathic pain without distinguishing between the various
What
subtypes.
are these observations on page 267 at line 22?
Line 2.
No, sorry, line 22.
Line 22.
Page 267.
That's the observations is the data in the patent, the data that is there.
I see.
And that would motivate you to do the further tests and confirm the efficacy. So, my lords, the upshot is that both respondents' experts agreed that they would be interested in the claims of the patent, and to the extent they had any doubt, they would carry out the tests in the patent, which were the standard tests to demonstrate efficacy against neuropathic pain, and that these would be routine to do. So if we go back to Article 83, the allegation has to be that the patent does not in fact provide an enabling disclosure, because something which isn't plausible is not enabling because the skilled person wouldn't try it. But if you would consider trying it and it works, then the disclosure is enabling. So if the ultimate question is, does the specification disclose the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art, the answer would be emphatically yes. The skilled person could and would put the patent into effect across its scope. They would do the routine work on animals as we've seen, and that was held by the judge to be sufficient to fall within the claims. And then, if necessary, they would progress to putting into humans as so many drugs worth of pain, even though they'd not yet been approved. And so they would find out it does in fact work across the scope of the claim as construed by the courts below, including for central pain. And for one or more of these three reasons, we say the Court of Appeal applied the wrong test. And if they'd applied the right test, they would have reversed the finding of the judge. Finally, on plausibility, my lords, can I pray and aid the approach adopted in other EPC courts? We've set out this at paragraphs 93 to 102 of our written case, at pages 170 to 173 of the bundle. I accept that none of them expressly deal with the argument as dealt with below and reject it, but that's because in our submission the argument doesn't even get off the ground in those countries because of the much more limited role for plausibility, which is properly confined. In the French case, which is at Authorities tab 7, I'm not sure there's time to go to it now, we emphasise the passage in bold at paragraph 95 of our written case, where they explain that it doesn't matter if it doesn't work for every type of pain, because the skilled person wouldn't expect it to work in every case anyway, given the complexity. In the Swedish case, which is at Authorities tab 80, the respondents say it's not clear that the central pain point was argued. We don't really understand that because it was activists who are one of the respondents before you who argued it, and I'm told by those instructing me who attended the hearing that the point was not only clearly raised by their expert, Professor Bennett, in his report, but it was also relied on in closing submissions, and it didn't have any effect on the outcome. And also we have the German case in tab 87, where the point wasn't accepted and didn't succeed. And moreover, my lords, we have a number of other countries where infringement proceedings have been begun, but the various generic companies sued didn't even think it worthwhile to challenge the validity of the patent on this basis. That's Denmark, Spain and the Netherlands. And there are other countries where the national authorities have imposed conditions restricting prescription for pain, but there's still no validity challenge on this basis, Italy and Portugal. Finally, as far as... I'm sorry, I'm probably going too fast, my lord.
In relation to the French case,
yes,
the reasoning that you've highlighted on MS 171 is that reasoning, I don't think, is spelled out in the EPO case that you took us to about the treatment of leukemia.
yes.
You remember the one I was talking about,
yes.
CML?
Yes.
But do you say that the reasoning in the French case is is to be understood as being also the explanation of the board's decision in the CML case?
No, I think I would suggest that the CML case was slightly different because they had, in the CML case, there was no evidence in the patent. There was one sentence which I showed you which says it's similar to another drug, and then there were some tests referred to which weren't the right tests. And the board in that case said, well, you would know to do the right tests based on your common general knowledge, and that would be enough. And anyway, there's sufficient in the patent to allow you to use later acquired evidence too, which is just this one sentence saying it's like another drug. So I think this...
But the point you were highlighting there was that, I thought, that the claim, well, there were two claims. One was for the treatment of CML generally.
Yes.
And then a second claim was for specifically the treatment of CML, which was resistant to an existing treatment.
Yes.
And the second claim wasn't made out.
Yes.
But that didn't knock out the first claim.
Indeed.
So the fact that a subclass wasn't established didn't mean to say that the wider classification wasn't the subject of a valid claim.
Yes. Yes.
And I was wondering about the reasoning. Well, I just wondered if reasoning of a French case.
I can see. I understand. I'm sorry. I'm
related to that.
That is. I can see it's a similar argument, and it's also we would say it was parallel with the Bristol-Myers Court of Appeal case I took you to this morning, showing that you would never expect a drug to work for every patient. So that's why you can't impose the standard.
Well, that's the CML case, isn't it?
Yes.
Yeah.
Yes, as well. Yeah. Finally,
These are
all parallel cases, the same patent being attacked in other countries within the EPC. There are also some cases where, not involving pregabalin, which are relied on by my learned friends, two Merck cases at tabs 84 and 85. But in our submission, all those establish is that if a research program is required to establish workability, that's too much, and that's, we say, entirely consistent with the EPO and English cases we've already looked at. And the final point is, of course, that the European Patent Office granted this patent without questioning the sufficiency of the claims. The patent was opposed in the European Patent Office, but sufficiency wasn't raised, only novelty and inventive step were raised, and the opposition was rejected. But in giving its decision, the opposition division did state at paragraph 2.1 that the problem is correctly solved by the patent in suit, which shows enough pharmacological data. So I accept that this precise argument has never been raised in the European Patent Office for this patent. But insofar as the European Office has looked at the patent, both in examination and in opposition, it didn't find there was any problem with the data.
what were the issues? Novelty and
Inventive step. So obviousness.
And we have that decision.
Yes, I haven't got that with me. I'll bring it in the morning. So, my Lord, those are my submissions on our appeals. I need to deal very briefly on plausibility. I need to deal very briefly with my learned friend's cross appeal on plausibility, and that's dealt with by the Court of Appeal at paragraphs 129 to 134. And as you all have gathered from my submissions so far, in our submission, my learned friend's appeal turns on a very restrictive interpretation of the Salk judgment in the EPO, and effectively amounts that you have to apply the test used on the facts of that case to every other case. But I've already shown you that the EPO doesn't treat Salk in this way, and it distinguishes Salk in appropriate cases, and it adopts a much more flexible test. And the EPO itself acknowledges and recognises that the facts of Salk, and indeed Johns Hopkins, were extreme. It took Salk many years to identify the hormone which does the things required by the claims. And in Johns Hopkins, there was material in the patent to suggest that the molecule was in fact different to the others in the superfamily it was alleged to be a member of. So we say the facts of those cases are very different to the present one. In terms of the policy underlying why the test for sufficiency should not be the same as the test for obviousness, we rely on the reasoning of Mr. Justice Henry Carr in the Activist and Lilly case, and we've set out those passages at paragraph 109 of our written case. he explains why there's no good reason for the test to be equivalent. And we also have it on high authority that those tests are not the same, and we refer to Lord Hoffman in the House of Lords in Connor at paragraph 37, tab 13 of the authorities, where he says that they are different.
And that's your case at paragraph, this is 109, yes?
Yes, it is. My Lord, it does appear that the respondents have backed off in their reply case, and they no longer say that it has to be the same test for obviousness as for plausibility. They appear to accept that the EPO authorities we cited in our case mean it's not necessary that a patent should contain data or other experimental results to be plausible. In other words, SULC is just an example of the principle being applied, and indeed an extreme example, because in that case there wasn't a shred of evidence to support the claim. And we contrast that with the evidence you've seen in this case, accepted by the judge, that the claims to peripheral neuropathic pain were plausible, indeed were exciting and would be pursued, and the low threshold, this low threshold is clearly met for claims 10, 11 and 12, as well as claim 3 for the reasons I've explored, and for all the reasons given by the interveners, FPIA, ABPI, CEPA and BIA, any higher threshold would act as a significant deterrent to entities working in this area, and would be to the detriment of society generally because of the impact it would have on R&D in the pharmaceutical sector. It would result in the retrospective invalidation of multiple patents in the UK, which are valid in other EPC states. And so for all these reasons, my learned friend's appeal on plausibility should be dismissed. My Lords, finally, I turn to construction. We have touched on that already. It's a standalone point. It's not subsidiary to the plausibility appeal in any way. Indeed, if we're right about construction, the plausibility appeal is unnecessary. Nor does it run contrary to our submissions on plausibility. In fact, it goes hand in hand with what we've already said, but in my submission, the argument is even more powerful if your lordships were to reject our appeal on plausibility. That's because there's an additional reason to construe the claims as we submit they should be construed, namely to avoid an implausible construction. So, my Lord, the starting point is the specification of the patent. The specification acts as its own dictionary, and given the acknowledgement that definitions could vary at the priority date, it's necessary to look to see what guidance the patentee gave. Now, we've looked at that briefly, but perhaps it's worth returning to. It's page 922 in the bundles. And
4.3.
it's the, sorry, 923, I apologise, yes. Passages in paragraph 3 and paragraph 6. And I think your lordships have my submissions on these passages. All of the neuropathic pain types listed in paragraph 3 are peripheral. And this is an important signpost to the skilled reader in our submission. Then we see in paragraph 6 a reference back to the pain conditions in paragraph 3. And we have the additional sentence, neuropathic pain is described as pain caused by injury or infection of peripheral sensory nerves. That's at column 3, lines 52 to 53. And as I indicated earlier, although the judge pointed out that statement is still true if neuropathic pain is deemed to include central pain, because as a matter of English language it is strictly non-limiting, that's only one way of understanding the sentence, and we submit it's not the natural one. And when read not through the eyes of a lawyer, but rather through the eyes of the notional skilled person to whom this document is addressed, it is clearly another signpost, in addition to the material in paragraph 3, to suggest that central pain was not within the contemplation of the patentee. And the sentence is also consistent with the further list of conditions in paragraph 6, all of which are again peripheral and not central neuropathic conditions. Now, we also accept that both lists in paragraph 3 and paragraph 6 are said to be non-limiting, but this is where we rely on the common sense approach of the skilled person, and if necessary, the justem generis rule, which is really just a legal way of expressing the common sense approach. And we say here the genus here is peripheral neuropathic pain conditions. And
Where is the non-limiting reference?
the non-limiting reference is in paragraph 3, it's line 28, yes. Such disorders include but are not limited to. And then in paragraph 6, line 53, after the neuropathic pain sentence, it says it includes but is not limited to.
Yes, but it depends whether you read that as related to the previous sentence.
Yes, but the judge certainly seemed to place a lot of weight on what he said were the non-limiting words in these two passages. And of course, the two most well-known central pain conditions, stroke and multiple sclerosis, are conspicuous by their absence, and we say that the skilled person would notice that, and that's a further reason for thinking that the claims and the specification are limited to peripheral neuropathic pain. Now, as well as the specification, it's right that the patent must be interpreted in the light of the common general knowledge at the time. This is part of the relevant factual background, and there's no suggestion on this side of the court that the interpretation of patents should be different to the interpretation of any other legal document. But in our submission, that doesn't change the interpretation outlined above. If anything, it reinforces it. And the reason for this is that it was accepted that there was no universally accepted definition of neuropathic pain at the priority date. Indeed, neuropathic pain was often used as a shorthand for peripheral neuropathic pain. So the skilled person would have been well aware, reading the patent, that the reference to neuropathic pain could mean only peripheral neuropathic pain, and the skilled person would look at the context in order to verify this. And we submit that the contents of paragraph 3 and paragraph 6 provide this context. Now, the judge and the Court of Appeal referred to the IASP, that's the International Association for the Study of Pain definition, and that's set out in paragraph 67 of the Court of Appeal decision on page 562. But as it wasn't established that this definition was the default definition that everyone used and no one would use any other definition, we submit it can't assist. And indeed, the applicability of this definition was not supported by the evidence before the judge and the Court of Appeal. We have all the source materials in the bundles, but I think in this case, all I need to do is just refer you to the evidence that's set out by the Court of Appeal in their judgment, and there's no need to go any further. So if your Lordship would look, please, at paragraph 110 of the Court of Appeal decision. So probably starts at 109, I think, sorry. 109 and 110. So I took Dr. Scadding, first of all, to the passage at 110 of the Court of Appeal decision on page 571. And he accepted there was confusion about terminology in the early 90s, that there was no default definition. Yes, there was, he says, and then there should be a break there. So the next question is, someone would always have to look at the context to see what was being meant precisely. So, for example, when an author used the term neuropathic pain, whether or not he or she meant to include central pain would have to be looked at in context. Yes, although by then some people were using the broader terminology, but there might be instances where they were not exactly. One would have to look very carefully, as you point out, at the context in which it was being used.
I'm sorry, so you, as you read it, you said, although by then some people were.
Yes, yes. So there was a mixed use. That was the evidence. Some people were using neuropathic pain in the broad sense to include central pain, but others were not, and you'd have to look at the context. And this evidence of Dr. Scadding, that's the respondent's clinical expert, was also supported by Professor Wolfe, who was my neuroscientist expert, and that's at paragraph 111, where the court recalled Professor Wolfe's evidence was that the term neuropathic pain, rightly or wrongly, was commonly used at the priority date to mean peripheral neuropathic pain. So then, in the context of the common general knowledge, I asked Dr. Scadding about the passages in the patent, and that's the material at paragraph 109, where he gave, in my submission, clear answers that he thought it would be limited to peripheral neuropathic pain. And the Court of Appeal dealt with this in paragraphs 114 and 115. They state, particularly on the top of, in 115, the top of page 572, they explain, although there was a usage of omitting the word peripheral, there was, as Mr. Mead submits, no usage of the term so as to mean that central neuropathic pain is excluded. And with the greatest respect, we just don't understand that passage, that sentence, in the light of the evidence which they've quoted in paragraph 110, where Dr. Scadding accepted that there was use of neuropathic to mean only peripheral neuropathic pain, and the evidence of Professor Wolfe in 111 that neuropathic pain was understood in some circumstances to mean only peripheral neuropathic pain. So we submit that the reasoning of the Court of Appeal just doesn't, with the greatest respect, stack up, because it was common ground between the experts that there was a use of neuropathic pain to mean peripheral neuropathic pain only, i.e. excluding central pain, and so the skilled reader of the patent was entitled to question whether the references in the patent meant peripheral only or peripheral and central.
I think usage is perhaps used in a technical legal sense. There's no convention according to which if you refer to neuropathic pain, you are necessarily and in every case excluding central neuropathic pain.
Well, if that's the case, then we say that the evidence of Dr. Scadding was determinative at 109, where he said, well, so you don't know what it means, and if you look in the context, I would understand it to mean peripheral.
Yeah.
So
I think the Court of Appeal is probably just saying it does depend on the context.
So in that case, we say that the court should have placed weight upon the evidence of the skilled person who was before it and the evidence they quoted. And we also don't understand the argument that just because Claim 1 is a broad claim to pain, that somehow affects the construction of Claim 3. We would respectfully submit it doesn't tell you anything about the intended breadth of Claim 3. There are later, even narrower claims, so one can't tell one way or another what is meant by Claim 3.
That what they deduced from the evidence was that sometimes it meant peripheral, sometimes it meant either sort. Which was the correct context and conclusion in this case was a matter for the court and not for the experts, and they concluded it meant everything.
Yes, I accept that it is, of course, a matter for the court, but when there are no reasons, we respectfully submit to construe it in the broad sense, and the expert who understood the terminology at the time and could explain how that terminology would be understood by the skilled reader of the patent. It's directed to that skilled reader. He was such a skilled person. We say that the court should have placed more weight on the evidence before it and not reached the conclusion it did. And the court refers to the skillful, in inverted commas, cross-examination of Dr. Scadding as if there was some kind of trick being deployed. We respectfully submit there was nothing skillful about it. The expert was just answering the question in a way consistent with his common general knowledge. And recall, of course, it didn't even occur to Professor Wood in any of his 5 reports to mention central pain. And so we respectfully submit the court should have been slow to depart from the views of the skilled person unless there was good reason to do so. There was no good reason to do so here. There was no dispute between the experts. These were technical terms. Evidence as to their meaning is admissible, even if the evidence is there's no fixed meaning. And in the circumstances where there's no evidence to the contrary and no basis to disagree with the analysis, the courts below were wrong not to accept the expert evidence.
Well, it might be thought that it wasn't really a matter for expert evidence, that if one's construing the document, and the document in the detailed description in paragraph 6 tells you what the document means when it talks about neuropathic pain, that's that.
Well, of course, that was my primary submission, both to the judge and the Court of Appeal. But to the extent that the expert evidence is admissible because it is evidence of technical terms and how they would be seen, then we say it all goes one way. And finally, my lords, we rely on the principle of the validating construction. I'll address you briefly on this from a patent perspective and then hand over to my learned friend Lord Panic to show you how it's supported more generally.
The Court of Appeal's construction is simply inconsistent with what's stated in paragraph 6, isn't it?
But that's our submission, my lord, yes.
Well, neuropathic, well, it just wouldn't be true, would it, to say of the central pain that it's caused by injury or infection of peripheral nerves?
Well, I think the judge held that meant, in brackets, and it's caused by other things as well. But
well, his reading is as if it said maybe.
Yes, is only.
Is inter alia.
Yes, but of course we say that's not the primary.
It's quite an odd series of claims, actually. It starts at the very, very high level, all pain, and then it seems to exclude, as a specific head, does it, nociceptive claim?
Well, I think
but
that
then
would be...
it does include inflammatory pain, which is a type of nociceptive pain.
Yes.
And then it goes to neuropathic pain, and the question is at what level or how embracing that term is meant to be. As
yes.
my lord says, get back perhaps to paragraph 6. But it isn't easy quite to understand the thinking of the claim.
Yes, I mean, why, as it were, strain at the gnat when you've swallowed the camel in claim 1 of treating pain?
Well, of course...
Is this simply the way these things are set out?
Yes.
You start at the highest level of generality and then...
You don't include every level, that's the curious thing. You miss out, particularly most types of nociceptive.
Yes, I'm not sure there are many types of nociceptive pain that aren't... that you use a drug to treat. Clearly one doesn't take an aspirin to stop yourself hurting your finger on a drawing pin. That's a type of nociceptive pain. The types of nociceptive pain that are clinically important are inflammatory pain, cancer pain, post-operative pain. But it is right that they have been divided up into their narrower categories, and we say that's the skilled person would also understand neuropathic pain.
Yes, I see. You've got burn pain and things like that.
Yes. So, my lords, validating construction, we accept it's only an aid to construction, but it can be valuable in circumstances such as the present, where there is a true ambiguity over the terminology used. And so this argument arises only in circumstances where the plausibility appeal has failed, but if it does, it provides strong additional grounds for limiting Claim 3 to peripheral neuropathic pain, because if the skilled person sees these claims, sees the dual meanings, yet one of them is inconsistent with the experiments in the patent, and therefore implausible, but the other is consistent with the experiments, plausible, and also in line with the wording used in the patent, which is restricted to peripheral conditions, then we submit the skilled reader would think that the patentee had intended for the version which not only saves the validity of the patent in the legal sense, but is also the only plausible meaning as a matter of technical disclosure. we submit there is basis to apply this principle to patents. It's equivalent to the application of business common sense. Contrary to the respondent's submission, it doesn't depend on what is pleaded because it arises solely from the words of the document and the common general knowledge, which is the basis for all patent interpretation. And the premise is that the skilled reader would avoid a ridiculous result or one that clearly wouldn't have been in the contemplation of the patentee. And it's no answer for the respondents to say there's no need for it because the patentee can always seek to amend its patent. The court will be aware there are strict rules against added matter which prevent the patentee from amending in a way which was not disclosed in the original application. And of course, we see the respondents objecting to the application to amend in the present case in any event. My Lord, in our written case, we've shown cases where this maxim is applied to interpretations of prior art, which are referred to in the specification. So if there's a reference to some prior art in the specification, the skilled reader would be understood to interpret the claims to exclude the prior art, and we've given you the references to that, paragraph 161 of our written case, including the Court of Appeal in the Virgin case. Also, Lord Justice Floyd in the Stretchline case, Authorities 5, tab 49, where he explained that the maxim can be applied to a patent to avoid an outcome which is foolish or one which the patentee clearly wouldn't have contemplated. And we've also shown it can be applied in the context of sufficiency in the 3M and Renix case, which is Authorities 4, tab 34 at page 342. And we submit that it's consistent with the legislation generally, particularly Article 69 EPC, and the cases in Terrell, which are referred to by the respondents, are no longer good law in the light of the recent decision of this court in Activists and Lilly. It's also applied by the EPO. The leading case in the EPO on this point is case T 190 of 99, which is recited in the casebook at page 303 and has been cited by FPIA in their intervention. I'm afraid the extract didn't make it to the bundles, but if I can hand up that passage to your lordships, and you can just see how the EPO approaches the question of construction. And so this is from the white book of EPO case law, which is updated every couple of years, and you've got some extracts already in the authorities bundle. It's the general principle of interpretation of claims in the middle of page 287. And if your lordships would just read that first paragraph under that heading, we say that's consistent with the approach we submit should be adopted here.
So are we to equate synthetical propensity with validation?
Well, it's a mind willing to understand, not a mind desirous of misunderstanding. Building up rather than tearing down.
Yeah. It was just an interesting phrase.
Indeed. And so, my lords, my final submission, before I hand over to my learned friend just before the break, paragraph 117 of the Court of Appeal is where the court dealt with this. And Lord Justice Floyd seemed to accept that it is appropriate in certain cases where there are two possible meanings of a term to adopt the narrow meaning if there were common general knowledge reasons for saying the wider meaning led to a claim extending to implausible embodiments. And so far so good. But we don't understand why he didn't go on and apply that here, because he seems to suggest that the implausibility of central pain was not clear-cut enough, and so he couldn't expect the skilled person to reject it. But this conclusion that he reached is inconsistent with his findings in paragraph 121, where he says that the skilled person would naturally divide neuropathic pain into two notional components, and that the central pain element was implausible. And given that this was all based on common general knowledge...
Where's he saying
Well,
it's implausible?
121 is where he says it should
division,
be...
yes.
Division, and then the upshot of that is that the claim, because it encompasses the finding of the judge, central neuropathic pain is implausible.
Yeah.
And when he rejects all the
Yeah,
points...
the end
we
of
put.
127.
Yes.
Yeah.
And so we submit, because there was a genuine ambiguity, because this ambiguity arose solely from the common general knowledge, applying the principle, as he referred to in 117, and as we've seen in the cases more generally, he should have reached the opposite result. If he made his findings on plausibility first, we submit that if those findings are right, he would then have concluded that the patent should be limited to the validating plausible construction, and that for all the reasons I've outlined, and for the additional reasons which my learned friend Lord Panic will now turn to, he should have found that the claim 3 was limited to peripheral neuropathic pain only. So unless I can assist you any further, I'm sorry, I apologise to my learned friend and to the court for overrunning. Those are our submissions on plausibility.
I think that probably means that it's not sensible to think of calling on your co-leader to...
Can I just tell your lordships what I need to deal with tomorrow
yes,
morning?
by all means. You've certainly got a couple of minutes, because that clock is fast.
Yeah, I've got to deal with validating construction. There's very little I want to add to what my friend said. Secondly, I need to deal with abuse of process. And thirdly, I need to deal with infringement. The first two are contingent on the court not accepting my friend's earlier submissions. If he's right, if the court accepts his submissions, then my first 2 points don't arise. But I will, of course, address them. And I have until, I think, lunchtime tomorrow, on the basis, if I understood my Lord Mance, we're starting at 10:30 tomorrow morning.
Yes, we are.
Yes. So that's...
If that's
I don't think it's sensible for me to start on the substance of it today.
definitely
Your
not.
lordships have heard, I suspect, enough for today's purposes.
we have enough to think about. Yes.
Indeed.
Right, well, we will resume at 10:30 tomorrow, and sit, I'm afraid, only till about 3:25 or so.
Indeed. Thank you.